Hello and welcome. My name is Mark Blatstein, the physician founder of Physician Pre-Sentence Report Service. Today, I'm going to go through legal representation should be your first decision, and you need to be asking questions in order to choose the right attorney for you. So if you hear that there's rumors that the feds have been asking questions, you get a target letter, which is asking you to come in and appear before a grand jury. The minute you have a feeling that there's trouble brewing, you need to get legal representation. And I'm going to go through uh, the different things that you need to do in order to find an attorney that's good for you. And so you want to find an attorney that practices federal criminal defense in federal court. You want to know if they have experience in cases like yours. Sounds like common sense, but really don't take anything for granted because you may not be making these great decisions for yourself. So bring someone along with you who you trust so they can be a sounding board and a neutral party. Begin interviewing attorneys is your opportunity to find someone who has a proven track record of handling, number four, handling cases like yours is important. They should be willing to provide, number five, several current or past clients for you to speak with so that you can get some of your answers to some of your concerns. Also, they should be willing to provide several sentencing memorandums for you to review. Now, the sentencing memorandum is a legal form or legal document that your attorney is going to submit to the court about a week before sentencing. This should be information that's about you. It shouldn't be all legal all the legal stuff that a judge already knows about Booker. This should be things that are specific to you. If the attorney says that, HIPAA, everything should be private, they're right. And it's a good thing that they mention that. But having a PDF document in Adobe, there's the option where you can redact all personal information. And this looks better than using a black magic marker. You need to feel comfortable with your chosen attorney, which is just one more step in the right direction as you begin to develop a successful legal team. You may ask the help break the ice. Ask the attorney why they decided to practice law and what was their best case or federal case sentencing result. Next, you can ask them when do they feel it's a good time to start preparing for your pre-sentence interview. And in my opinion, the answer is today. It's as soon as you get to know your attorney. Continuing, you want to know whether they charge hourly or flat fees, and if there's a payment schedule, so that you don't have to give all the money up front. And it's important. You want to know, let's say you're thinking about going to trial, or maybe there's a plea in your future, which I didn't know this, so I had to swallow, my own. I, I suffered my own problem here. How many you want to know? How many problems, how many trials or appeals, or what percentage have they won recently over the past 3 to 7 years? You want to know? I appealed my indictment. I lost. And there's a reason why the feds or the Department of Justice has a 95+% conviction rate. You don't want to anger the court before you meet and ask for leniency. I mean, the perfect example here is Sam Bankman-Fried. In his time before he went through trial, he lied on the stand and he was tampering with his witnesses. That's playing Russian roulette with your life. If it's a single practitioner, what's their current caseload? Are they too busy to be able to, handle another case? So my understanding is that for a single attorney with a small staff, 2 or 3 criminal trials per year is a lot. Don't feel bad if you have a federal defender because they can be as good, if not better, than private counsel. But as in private counsel, there are good auto mechanics, there are bad auto mechanics. So you need to do your due diligence here too with the federal defender. While this is not yet law, and your attorney may or may not be familiar with it, there's something called the Fairness and Restitution Act. And it is a joint venture with a nonprofit and the National Association of Criminal Defense Lawyers. So that if you anticipate owing restitution or a large monetary fine with the government, they address 5 or 6 several things. They say that you should be able to show actual loss sustained by the victim as a direct and proximate result of your actions, the defendant's actions. Eliminate joint liability and assure that the defendants are only responsible for the financial losses that they or you caused. Provide a right to an evidentiary hearing for proving or disproving the amounts included in a restitution order. Request the stay of the court to change the statutory period of liability from 20 years to 10 years and to prevent extensions. Again, these are requests from your attorney to the judge. The judge may or may not agree, but it can't hurt to ask. Accept any reductions in restitution amount owed from being counted as income for tax purposes. And lastly, you want to verify that the no insurance box is checked on the judge's order. And the last thing is that if you have time and if you are comfortable and able to go through this particular list, if you have time, try and see if you can go to a sentencing hearing where your judge and see how your judge, how he performs or how he defends his client. You may or may not have time. I hope you found this all very helpful. I say this because I too had a felony conviction in 2006, but I was grateful to get my license to practice medicine back in 2010. But I didn't know that we didn't listen to the judge when he said he did want to see me back in his courtroom. I went back to the courtroom and he sent me back to prison. I hope you've enjoyed listening to this and have a good day.